For joining us, Darko. Hello, Darko. Unmute your mic.
Thank you very much, Samson.
Right. So let's begin this way. You filed the charges on Tuesday, correct?
Yes, Samson.
On the 11th.
But if you
hold on. Let me ask you questions before you address what you want to. Hold on. First, I say you filed the charges on the 11th, which is on Tuesday, correct?
Yes, we filed the charges on Tuesday.
Right. We are told that Ofori-Atta has not been served, according to his lawyers. So what are you waiting for?
Again, this brings me back to the inaccuracy and the misinformation that we believe that sometimes is deliberate and sometimes is out of, say, ignorance, that feed into the whole idea that the OSP is probably not doing its work right, and that feeds back into the credibility issues. These are the processes that happen. So because Mr. Ofori-Atta is not in the jurisdiction, and as every lawyer is aware, when it comes to criminal law, you do not serve the lawyers of the accused person. It has to be served on the person. So we have filed the charges. We've applied for summons to serve him where he is. So that is a process. And again, this has also been a problem where people keep rushing the OSP, but the OSP will listen to people, but it does not pander to people. It follows due process and it follows law. If you recall, when we are at the investigative stage, a lot of lawyers were even saying, go to court and file charges when we were at investigative stage. And yet they were insisting, go and file, go and file. And we are told them that we were at an investigative stage. And at investigative stage, the law enforcement agency has the power to try to bring down an accused person so that it can go through the investigation and finally present the person before court. In the case of Mr. Ofori-Atta, it is one of the reasons why we had to put him on Interpol red notice, because he had given us the excuse that he was so sick. And we had our intelligence to show that he wasn't so sick and that he had been trotting around the globe. At least he's on record to have been going to the United Kingdom and Hong Kong and a few other places. And so we had to get an arrest warrant on a charge and then restrict his movement from moving across the world. So we were able to restrict him to the United States. Now, people have said that he offered us a process that we could have spoken to him and we did not take that and all that. So you see, when you are investigating someone, like someone said, what was our plan? Everybody has a plan. An investigation can take so many years. I'll give you a typical example. Americans were doing something on romance scam. It took them 6 years. We're investigating Airbus. It took OSP roughly 6 years. Ofori-Atta's case, it has not even taken us 2 years, and yet we are hearing a lot of a narrative that we have sat down for everything to vanish and blah, blah. No, we have not sat down for anything to vanish. In fact, we have done this investigation in record time. Other investigative bodies are investigating Mr. Ofori-Atta for different things. Has anyone presented their work yet? Even SML, we are told that there were other bodies that were investigating it.
I just mentioned a while ago, the Attorney General has announced that they have also been investigating SML.
Yes.
Which
so the point I'm making
involved.
is that there's a lot of unfairness against the OSP, and it's rightly so, because you see, when you are independent body and you are being pushed by the left and the right, these are what will happen. And when you fight corruption, it fights you back. The people who are fighting are so sophisticated, have money, and they're able to spread a lot of misinformation, because their whole idea is that this job rests on the trust of the people. And so if we're able to pollute the minds of the people against the body and they lose trust in it, then it won't work. Some also believe that our party is in power and we must have somebody who is within our party.
When will Ofori-Atta be served with a charge sheet?
So it's a process. Currently, the court will give us a date. I mean, they gave us a date, but my understanding is that the registry has called us back and said that there have been a few issues, and so they will have to reschedule the date. So when the new date is given, those processes will be done. And like I said, in criminal matters, we don't serve lawyers.
No, that is clear.
That is clear. Yeah, but it's clear. But
let's stay on this issue. Let's stay on this issue. Let those who want to peddle what is inaccurate go ahead. You can't stop them. You have educated, so you stay there. Could you have gone for this summons before you filed the charge sheet?
No, we couldn't have done that because we were still in the investigative stages and we couldn't have gone to court to that. That's why we had explained that.
The question that is being asked you again is, in January, when he was leaving, why had you waited up to that point when you hadn't filed charges? You should have filed charges by then.
Something that brings me back to the subject, and that's why it's so interesting. Sometimes you don't understand what some people want. I've just said that investigations do take a while, and SML is one of the most difficult investigations the office has done because of the complexities involved and because we needed to go to other jurisdictions for evidence and all that. And we have used less than 2 years to do this investigation. And this investigation started, the complaint came to us somewhere in December 2023. When the complaint came to us, the same December, I think getting the end of December, it's when President Akufo-Addo set up what do they call
KPMG.
The KPMG. KPMG took about 3 months, so we had to pause and still be doing our work in secret and be getting information. They did their work for about 3 months. And then we needed a copy of the KPMG report, which we never got till it was made public, right? And it was made public somewhere in April and the rest. And then from April thereabout, we're still working in the SP. Someone had applied for his removal. He had to go through a whole impeachment procedure. Just look at the CJ going through impeachment procedure, whether she had even the presence of mind to even focus on your way. And the SP were going through all these things. Just when it was done, another petition was brought for the SP's removal. He had to go through another impeachment procedure. So there have been a lot of bottlenecks in the course of the investigation. And so the investigation, even like I said, we've even done it rapidly than we should have done, because in such investigation, you take your time. It can even be just like Airbus. It took us 6 years. It could have taken us even 4 years. It's not about how people are so much interested in Ofori-Atta. It's about we following due process.
You should have organized a press conference when you heard that Ofori-Atta was at the airport.
When we organize press conference, they say we talk too much. When we don't organize press conference, they say we are conniving with Mr. Ofori-Atta. How on earth could we have even connived with Mr. Ofori-Atta? Someone we had put on red notice. Someone we had the agency that has been investigating and going after him. So if you say we could have done a press conference, that is your view. But the SP would have evaluated all these things at the time. Remember, it was the transition period. That's when he left. And he had given prior notice to almost everybody on a medical ground. Now, OSP had its own intelligence that Mr. Ofori-Atta is not likely to return to the jurisdiction. However, the processes for triggering all these things was not just a one-day thing that you could have done. Just as people make it seem as if it's a very simple thing, just organize a press conference, people go to the airport and stop the plane at the tarmac and then remove Mr. Ofori-Atta from it. As you said, these are all security matters. He has gotten clearance from the highest office of the land. And the SP was making a point that he had not enjoyed cooperation from all the agencies that are supposed to support us. We're in OSP where security officers can be withdrawn at random. You are there, officers are saluting the office and saying, we have been asked to return to base and all that. We have gone through a lot. And what the SP was trying to say, that he was not enjoying cooperation, that even if he wanted to write to say the immigration boss, that they would have stopped him. It doesn't mean that the SP was saying that he had even written to say the immigration boss. He had said that the person had clearance to travel from the highest land. And even if you were going to go to court, you're going to go to court on your assumption that he will not return. When the person has a medical excuse, has booked a hospital and all that. So people should understand the situation. It was a transition period.
Okay.
And even if you want to hang it around the neck of the SP that he has made the cut or whatever boat.
No, the point is that you have the powers of police. You could have effected an arrest. You don't need anybody's permission.
Yes, you have the powers of the police, but you just don't effect an arrest. We don't just arrest people.
Yeah, why?
We arrest people.
Why? You are like police. Go to the airport and pick him up.
No, we arrest people when we have sufficient evidence of a crime. Remember, the people have so soon forgotten. They think that when the petition was made to us, it was so clear on the face of the petition that Mr. Ofori-Atta was the alter ego of the whole SML scheme. It had to take diligent investigation to bring out Mr. Ofori-Atta as the ringleader.
Okay.
It was not just on the face of the
record. All right, Sammy.
And I have one example I want to give. I beg you. Just one last thought.
I'm coming to you.
Just one last thought to go. People have said that whatever has bolted, Ghanaians, it's not true. See, what the OSP has done, we have saved the nation. SML was going to be paid $2.6 billion in 5 years. We have saved the nation that amount. So that is enough money that OSP has saved. Yeah, $2.7 billion US dollars. We have stopped that now. What they have already been paid is 1.4 billion Ghana cedis. And this 1.4 billion Ghana cedis, the OSP is in court to recover that in the event they are found guilty.
Vicky suggests that it may be late because properties you would have frozen and all of that may have been concealed.
I don't even know why people talk about these things as if the men and women who are working day and night. OSP has Asset Recovery Management Division. We just don't do investigation. As we do investigation, we trace assets.
So you have traced assets in this matter?
Of course, we have traced assets. There's no case the OSP investigates without tracing assets. If you talk about MPA, if you even talk about MEF, which is our next case we're going to bring about, we have taken so much asset running into millions of Ghana cedis. But these are not matters we always disclose. That's why I've said that the law gives us the leverage to be able to carry Ghanaians along. We are doing it
so when should Ghanaians expect that the summons will be served on Ofori-Atta? When?
I cannot give a timeline because these are court processes. Let's allow the court to set the dates. Let's allow the motion to be moved. And as you are aware, when we move the motion and it's successful and is served on him, if he does not return to the jurisdiction to face trial, the judge and the Act 30 will commit him to prison. And after he has committed him to prison, then the judge will issue an arrest warrant, which again brings us back to extradition. And let me give you an example. Although Sedinam Tamaklo was convicted under Godfrey, he applied for extradition, and up to today, the US has not responded to them. Is that incompetence? Why do we treat the OSP as if? But sometimes I understand because the OSP stands in a certain critical moment where it is doing so many cases.
Okay. Thank
where
you.
So many assets have been
Hassan says he has a question for you. Please do it quickly. I need to take a break and then focus the discussion in the
Sami, thank you very much. I have a few questions. I asked them before you came in.
A few questions.
Was the OSP investigating Ken on SML on any matter at the time that Ken was leaving the jurisdiction?
He answered that.
If he was, and you said that you have sought cooperation of other agencies, for instance, is there any evidence?
He has answered that.
No, because you see,
you are asking questions.
We write to the courts.
I want us to deal with
You understand? And then thirdly, if now you are seeking cooperation from the United States, for instance, there was ample opportunity for you to have activated, Mutual Legal Assistance Act 2010, Act 807, to have taken advantage to get video link to communicate with Ken Ofori-Atta, and he was willing to do so. Why are you not doing that now?
Let me give you let me explain this one.
He's answering
I'll give you that. I'll answer you that one. You see, this whole idea that we should talk to Ken Ofori-Atta, we don't get it. Have you noticed that we have done our investigation and concluded without Mr. Ofori-Atta because he can come to our office and say to us that he will not say anything. So as investigators, we are aware. But we needed Ken Ofori-Atta physically here to go through the arresting procedure where we can finally place him before court. Because remember, we have never trusted Mr. Ofori-Atta's excuses. And when we started, many of you told us that we were inconsiderate. And now we have been proven right. And we were thinking that Ghanaians would rather say that the OSP was right after all, that Mr. Ofori-Atta was unwilling to return to the jurisdiction unless forced to come down to Ghana. So please, sometimes you should understand that the OSP is very professional. We know our work. We know what we are doing. We are the only state agency on record that is investigating Mr. Ofori-Atta, that has at least made a lot of steps and efforts. And the fact that we do something and sometimes we are not successful does not mean that we are incompetent. The fact that people run narratives for their own parochial interests and also for the interest of the people we are investigating does not mean that the OSP is not functional.
Sami, thank you very much. Thanks for your time.
I will explain my philosophy to you. And it's very simple. I consider bail and sureties, or I liken it to the collateral you give for a loan. When you give a collateral that is less than the loan you take, there's no motivation to pay back. You can let the loan go run its length, and then there's no collateral to fall back, and you go into default. In the same way, bail is connected to a case. So imagine if I have a case of 100 million, the exposure or the risk. We do a lot of investigation for the banks, for example, where somebody has stolen $90 million. And then you catch the suspect. Then you give him a bail of $20 million. Now, like I told you, assume at every point that every criminal is at least above average income. The fact that he beat the banking compliance and everybody to steal that money tells you he's not your average Joe.
So, as you know, some of the people who have been charged for millions of financial, mismanagement or corruption. For example, Kwabena Edu-Boaheng in the National Signals Bureau's case, he was a former boss. The bail sum giving him was 80 million with two sureties. Alhaji Abdul Wahab of the NAFCO, 50 million. Bernard Enchibo-Esiako, the chairman, Wontumi, 50 million. You had Charles Mensah, is in Niyama, Chatawale, he had 5 million, two sureties. Almost all the cases, they are looking for two sureties. Edwin Provençal, former boss, he 30 million, two sureties. And then you had the NSS, heads who were also arrested. And the courts are now reducing the bail sums for those who were not able to fulfill them. Some spent 2 weeks in jail, in custody, some spent less. Because it's difficult to come up with the fulfilling the conditions. Yes, Hassan, why are you guys, even in Parliament, you are raising this issue that bail is being used as punishment?
Yes, I think that this matter again has been discussed on this same platform before. And the overwhelming view is that it appears that bail is now more or less being weaponized, being used as a weapon to oppress, suspects or persons of interest with some very onerous bail terms and conditions. And I think that there has to be some kind of, realignment and regulated environment as far as bail is concerned. It has never been like this before, until just recently. And if you have observed, there are different agencies handling this kind of cases. You have the OSP, you have the IOCO, you have the NIB, and I think the CID as well. Most of the furor and indignation is directed at mostly IOCO. OSP, you will hardly find any instance where OSP will insist that somebody must be held in custody. And not many people have gone to OSP, except maybe one or two that you hear about them in the public, especially with the exception of maybe Poladomochi because of who he is. And even that one, the bail conditions were not such onerous bail conditions. Now, what happened to self-recognizance bail? We're in this country for the 8 years that MPP was in power. Can you mention one person who was held in custody because he couldn't meet any bail conditions? Can you mention one?
You may not know.
You see, we have had Stephen Opuni, Seydou Agongo, Dr. Kobna Dufour Jr., they have various chief directors, they have business persons. They were all released on bail right from the beginning. Second, you have another group, Dr. Tuforsin, Dr. Kobna Dufour Sr. himself, Alhaji Collins Dauda, Kweku Ajima Mensah, and all of that. They were granted self-recognizance bail. Then you have another category.
By police or by court?
By the court.
So we're talking about the police bail first.
Even at that level.
We're not talking about court bail.
Even at that level. You will never hear it. Richard Jakpa, for instance, was he ever detained? He never slept in custody for one day.
Do you know that for sure?
I am telling you for a fact. So all these things about, we need to tie bail to the sums that, apparently had been lost and so on and so forth. But there are people who have been held in custody unrelated to any loss of money. So why are you still holding them in custody? What are you trying to recover from them? In the particular case of Yoko, if you go to their functions, Section 3, it provides that the Yoko would recover proceeds of crime, for instance. So in the mind of the executive director, if from their investigation, you are deemed to have caused or misappropriated 60 million cedis, then he has to give you bail conditions amounting to about 60 or so million cedis. That is wrong. And I think that the application of bail should be regulated under Article 296 of the Constitution because it's an exercise of discretion.
What Raymond said? He said
his philosophy.
What's wrong with that?
Yeah, he said his philosophy. Now, there are people who have occupied that office before him.
Is that philosophy compliant with the law?
It is not.
Why?
It is not. Look, we should be guided by the provisions of Section 96, for instance.
Yes, what does Section 96 say?
It provides...
What does Section 96 say should be how to deal with bail?
I mean, it talks about bail not being excessive. That one is very clear. And if you have it, we can read Section 96 copiously for the benefit of the listeners. You see, bail is being used as a weapon to oppress even accused persons. Look, if you have a very solid case,
the law says
how long
the law says you grant the bail depending on the circumstances
of the case.
You shouldn't use the bail as punishment. It shouldn't be excessive.
That is what we are seeing.
Who determines that it is excessive or it is being...
At the point of inquiry, it is the agency that is doing the investigation that must exercise that discretion.
Right.
And it's a discretion that must be exercised, that they must exercise with, a lot of, empathy. But it appears that the whole idea is to convict you even before. We want to hold you in custody even before the trial starts. That is the whole intention. And I think that it is very wrong. Look, it has to be regulated by Article 296. But when you are exercising discretion, it must not be capricious, it must not be whimsical, and so on and so forth. But that is what we are seeing. Because the ED, for instance, when you heard, he said that his philosophy, so that makes it, capricious. And because people have occupied that office before, and we haven't seen some of these things before. It's the same law that we are applying, it's just different individuals. So he brings different philosophy to the office, and I think that it has to be regulated. It is, look, BNI, for instance, has investigated a whole lot of people. You will hardly hear anybody, maybe because he's a media person, coming from the media stock, because almost every case of Yoko is in the media space, especially if it has to do with any politically exposed person. So we have to be, as a country, watch it the way that we do. Otherwise, one day somebody will need Kotoka International Airport as surety. You need a property, maybe Tema Harbour. Because the rate at which we are going, 800 million, 150 million, 100 million. I mean, how many people have that kind of property?